Welcome back to the Constitutional Clarion. Australians are familiar with the fact that the Commonwealth Constitution is entrenched, meaning that it cannot be changed by Parliament alone. Any amendment has to go through what lawyers call a special manner and form procedure in order to pass, which in this case, the Commonwealth Constitution, means approval of the people in a referendum. But what about state constitutions? Yes, each state has its own constitution. Can they be changed by ordinary state legislation, or is a special manner and form procedure, such as a referendum, required? And can Parliament entrench anything that it wants so that in future it can only be changed by, for example, a referendum? This video, along with a companion video I will record later, explains what can be entrenched in state constitutions and in other state legislation, and how manner and form procedures work, and in some cases don't work. It's a bit complicated, but I will go through it slowly and clearly and give you some examples as well, so that if you stick with the video, I promise you that by the end you'll get it. And you will have a better knowledge about this than most lawyers and politicians, because manner and form is actually very rarely taught anywhere. To understand how this works, you need to understand a little bit of constitutional history. The British have a cardinal constitutional principle of parliamentary sovereignty. That means that Parliament can amend or repeal any law by the enactment of ordinary legislation, even a law that has a kind of constitutional status like the Magna Carta or the Bill of Rights of 1688. But when it came to setting up colonial legislatures, this principle conflicted with a desire to retain British control over the laws of the colonies. So colonial legislatures did not have the same degree of parliamentary sovereignty as the Westminster Parliament. There were three main restrictions on colonial legislatures. First, the monarch, on the advice of British ministers, could disallow colonial laws. Second, certain types of bills passed by colonial parliaments had to be reserved for the monarch's assent rather than receiving assent by the governor. Third, there was the doctrine of repugnancy. Colonial laws were void to the extent that they were repugnant to the laws of England. Now, repugnancy here does not mean, ooh, yuck, repugnant. It actually means inconsistency. So is the local law inconsistent, repugnant to, the law of England? But the problem here was identifying which British laws had this overriding effect. If it was any law, then colonial legislatures could do virtually nothing. After a controversy in South Australia, where the rather cantankerous Justice Boothby started striking down important colonial laws, such as the electoral law and even the constitution of the colony, on the grounds of repugnancy with British laws, the British government was persuaded to pass a law that clarified the application of this doctrine of repugnancy. Now, this law was the Colonial Laws Validity Act of 1865. It said that the repugnancy doctrine only applied where the colonial law conflicted with English laws that directly applied to the colonies or did so by necessary intendment. They were known as laws of paramount force. And the Colonial Laws Validity Act itself was one of these laws that bound the colonies by paramount force and could not be overridden by them. But no repugnancy arose in relation to conflicts with ordinary English laws. In Section 5 of the Colonial Laws Validity Act, it was also confirmed that every representative legislature in a colony has, quote, full power to make laws respecting the constitution, powers and procedure of such legislature, provided that such laws shall have been passed in such manner and form, that's where we get those words from, so in such manner and form as may from time to time be required by an Act of Parliament, and that means the Westminster Parliament, letters patent, orders in council, or colonial law for the time being in force in the said colony, unquote. Ignoring for the moment letters patent and orders in council, which we can probably deal with another time, the upshot of this was that colonial legislatures could only make laws respecting the constitution, powers and procedures of their legislature if such laws were passed according to the manner and form required by a British statute, such as those that included requirements about the reservation of bills for the monarch's assent, or set out in a colonial law. It therefore allowed the colonies, and later the states, to entrench certain matters in their constitutions by providing that they could only be altered by a law that complied with certain manner and form, such as passage of the bill by a supermajority, such as 2/3 of each House of Parliament, or approval by the people in a referendum. Because the Colonial Laws Validity Act was itself a law that applied by paramount force to the colonies and later the states, it overrode the power of the local legislature to make such laws without following the required manner and form. It was a higher law, which was a binding source of law that gave legal effect to this entrenchment. But what happens when you undo these British constraints, as indeed occurred with the enactment of the Australia Acts in 1986? The British constraints, such as reservation and disallowance, were removed with respect to the Australian states, and the Colonial Laws Validity Act itself was repealed. But this would then have allowed the state parliaments to amend any state law, including all state constitutional provisions, without following the required manner and form procedure, such as the referendum. So in negotiating the Australia Acts, the states had to decide whether they wanted to retain the power to entrench provisions by manner and form or not. There were effectively three options. One, get rid of manner and form altogether so that every state law, including the Constitution, could be changed by a later state law enacted in the ordinary way, as is the case in the United Kingdom. Two, extend manner and form constraints so that any type of state law at all can be entrenched, as is the case in the Australian Capital Territory. Or three, stick with the previous position of being able to entrench some things concerning the Parliament, but not other things. In the negotiations, some states actually wanted no entrenchment, others wanted wider entrenchment powers, and the compromise that was made was to stick to the earlier position that had been set out under the Colonial Laws Validity Act. This resulted in the enactment of Section 6 of the Australia Acts. Like the old Colonial Laws Validity Act, it's binding on the states and they cannot unilaterally change it. The key part of Section 6 says, quote, "A law made after the commencement of this Act by the Parliament of a state respecting the constitution, powers or procedure of the Parliament of the state shall be of no force or effect unless it's made in such manner and form as may from time to time be required by a law made by that Parliament," that's the state Parliament, "whether made before or after the commencement of this Act," unquote. Now you'll see there a lot of the same language that was used in the Colonial Laws Validity Act, but the constraints that had previously been imposed by British law have now been removed. As with its predecessor, it only requires that a manner and form constraint be followed if the law is one respecting the constitution, powers or procedure of the Parliament of that state. And that's actually quite a narrow category. The important thing to understand here is that constitution in this phrase does not mean the whole of the constitution of the state. Instead, it means how the parliament is constituted or comprised. So whether it has one house or two, or whether its members must be directly elected or maybe indirectly elected. In a 2003 case called Attorney General for Western Australia and Marquette, the High Court said that to determine what falls within the constitution of the Parliament, one must look to the features which go to give the Parliament and its houses a representative character. Laws concerning voting systems and electoral redistributions are therefore now also likely to be covered by the term constitution. But it all has to concern how the Parliament is constituted, not other subjects such as the judiciary and its independence, or the existence of local government, or setting out a Bill of Rights, for example. Now, what about that other bit in Constitution Powers and Procedures, which is the powers and procedures? Some have argued that every manner and form provision, including ones that deal with things like local government and other subjects, affect the powers of the Parliament or deal with its procedures in enacting laws. But if this were the case, then anything could be entrenched, because every amending law that didn't comply with the relevant manner and form would be overriding it, and therefore one with respect to the powers of the Parliament. This would defy the intent of Section 6 of the Australia Acts, which was to confine the entrenchment of provisions to that narrow category of the Constitution, powers or procedures of the Parliament. So in my view, and other people will disagree here, in my view, that broad interpretation is wrong. This leads to an interesting problem about whether attempts in states like Victoria to entrench a load of other things, including anti-fracking measures, are actually effective. Is there another legal basis for entrenchment outside of Section 6 of the Australia Acts? I'm going to deal with that in a later video, so look out for that one because it's actually quite interesting. To understand how manner and form works in practice, you need to understand that there are usually three different types of provisions that are relevant. First, there are the entrenched provisions. Now, these are the ones that Parliament is seeking to protect from amendment or repeal by the imposition of the manner and form constraint. So, giving you an example here, say, for example, Hypothetical Act, Constitution Act 1950, say in sections 8 and 9, it said, there shall be a legislative council comprised of 30 members chosen directly by the electors. It shall be compulsory for all electors to vote in elections for the Legislative Assembly and the Legislative Council. Second, there are the entrenching provisions, also known as manner and form provisions, which are the ones that identify the protected provisions and do the job of entrenching them by imposing manner and form constraints on their amendment or repeal. They provide that certain sections cannot be amended or repealed, or laws on certain matters cannot be enacted without following a particular manner, for example, a special majority vote in Parliament or a referendum, or a particular form, for example, a requirement that a law contains certain words. For example, Section 32 of our Hypothetical Constitutional Act might provide a bill that abolishes the Legislative Council or expressly or impliedly repeals or amends sections 9 to 15 or this section shall not be presented to the Governor for assent until it has been approved by the electors in a referendum. Okay, now the third type of law we're going to deal with here is the amending law or the repealing law, which is the one that later seeks to amend or repeal those entrenched provisions. For example, say we had a Constitution Amendment Act of 2024 and it said the Legislative Council shall be abolished, voting for the Legislative Assembly shall be voluntary. When trying to work out whether this amending law must comply with a manner and form procedure, you would need to ask yourself the following questions. A. Does the amending law seek to amend or repeal an entrenched provision contrary to the requirements of the entrenching provision? Now here the answer in our example is yes. Sections 1 and 2 of the 2024 law would impliedly repeal Section 8 by abolishing the Legislative Council and impliedly amend Section 9 by stating that voting is voluntary for the Legislative Assembly and removing the reference to voting in the Legislative Council because the Legislative Council would no longer exist. As the answer to the first question is yes, the next question, B, is whether the entrenching provision is itself doubly entrenched. This means, can the entrenching provision itself be amended by ordinary legislation, or does it protect itself by requiring that the manner and form requirement it imposes to protect other provisions also applies to amendment or repeals to itself? If it's not doubly entrenched, then the amending law will also have the effect of impliedly amending the entrenching provision so that it doesn't need to comply with the manner and form requirements. In this example that I've given you, our entrenching provision in Section 32 is doubly entrenched because it applies that manner and form protection not only to other provisions but to itself where it refers to this section. If the entrenching provision is doubly entrenched, the next question is whether it's really a manner and form provision dictating the manner and form by which the amending or repealing law can be enacted, or whether it is instead a purported abdication of legislative power. Any provision that says that the Houses of Parliament cannot enact a law without getting the permission of some kind of external body, such as a tribunal, a company, or even a local council, other than the people in a referendum, is a purported abdication of legislative power. State parliaments have no capacity to abdicate the power that's been conferred upon them by the Constitution, so such a provision would be ineffective. It may also be an abdication of power if the manner and form provision is so hard to achieve that it effectively prevents any future change at all. For example, if the manner and form requirement required 100% of the people voting in a referendum to be able to approve a change, then that would be so extreme that it would probably be regarded as an abdication of power rather than a legitimate manner and form requirement. Would a special majority of 75% of members in both houses or 75% of the people in a referendum amount to an abdication of power? Well, the answer is we don't know. We don't know where the borderline is, but it is something to take into account. Fourth, if it really is a manner and form provision, not an abdication, then the final question, D, is whether the amending law is one respecting the constitution, powers or procedure of the Parliament. Now, often people get this part wrong, including judges, and think that it's the entrenched provision that has to be the one with respect to the constitution, powers and procedure of the Parliament. But actually, it's the nature of the amending or repealing law that is at issue. Now, usually the outcome will be the same because the nature of the amending and repealing law will usually reflect the nature of the entrenched provision that it's trying to remove. But sometimes the answer can be different. So you do need to be very precise here about which law you apply this test to. The question is whether this amending law can be characterised as one with respect to the constitution, powers or procedures of the Parliament. If the amending or repealing law relates only to the judiciary or to local government or some other subject, then the effectiveness of the manner and form provision will not be supported by Section 6 of the Australia Acts. In the case of our example, the amending law does concern the Constitution of Parliament by seeking to abolish the Legislative Council. Whether a law about voluntary voting would fall within this category, however, is more debatable, but since the Marquet case, it may well do so. In 1996, the Queensland Parliament repealed Section 14(1) of its Constitution Act of 1867 by enacting ordinary legislation, despite the fact that the entrenching provision in Section 53 of that Act, which was itself doubly entrenched, stated that a referendum was required to amend or repeal Section 14. So how could it ignore that manner and form requirement? Because the view was taken that Section 14(1) only concerned the appointment of public servants, and that the law repealing it would therefore not be a law with respect to the constitution, powers or procedure of the Parliament, and therefore Section 6 of the Australia Act did not require that the manner and form constraint be met. It was also argued that there was no other means of giving effect to that entrenchment. No one challenged the validity of that repeal, so we don't have any judicial authority on the question of whether Queensland was right in its assessment that no referendum was required for that repeal. Okay, so that's how it all works. So let's do a couple of problems to test your understanding. Have you actually got it? Okay, first example, Section 18 A of the Parliamentary Superannuation Act 1988 of New South Wales provides that, quote, no bill amending any provision of this Act, including this section, may be presented to the Governor for assent unless it is accompanied by a certificate from the Parliamentary Remuneration Tribunal approving such an amendment, unquote. What if, in 2024, a bill was passed about parliamentary remuneration which was inconsistent with some provisions of the Parliamentary Superannuation Act 1988, impliedly amending them? What if no certificate was provided to the Governor? Is the 2024 Act effective in impliedly amending these provisions? Okay, hit the pause button here if you need to think about it. Ready? Okay. The entrenching provision in Section 18 A is doubly entrenched. See the words including this section. Whether a law about parliamentary remuneration is a law respecting the Constitution, powers or procedures of Parliament is doubtful, but at least arguable after the Marquet case. But the biggest problem here is that Parliament cannot abdicate its power to enact laws by requiring a certificate from some other body first. So the later law would be valid even though no certificate was given. Here's the second problem. Section 23 of the Constitution Act 1934 of Tasmania provides that the House of Assembly shall continue for a term of 4 years from the return of the writs for the last general election and no longer unless it's sooner dissolved by the Governor. Section 41A then provides the Assembly may not pass any bill to amend Section 23 unless not less than 2/3 of its members vote for passing the bill. Not that we actually want to give the Tasmanian government any ideas here, but suppose that in 2024 it enacted a law to extend the term of the House of Assembly to 5 years, but it did not get the support of 2/3 of the House of Assembly. Could its validity then be challenged in the courts? Again, hit pause if you need to think about it. Ready? Okay. A law that extends the term of a House of Parliament would most likely be regarded as one with respect to the Constitution of Parliament. A 2/3 majority vote is a genuine manner and form constraint, not an abdication of power. The problem here is that there is no double entrenchment. The entrenching provision in section 41A is not itself entrenched and can be impliedly repealed by any inconsistent later law, including this one. Right, got it now? So yes, it is quite tricky, but well done for having stuck it out to the end, and hopefully you've mastered it. Or go back and have another look if you haven't. I'll do another video, as I said, about attempting to entrench matters that go beyond constitution powers and procedures of the Parliament. But until then, thank you for watching the Constitutional Clarion, and I look forward to seeing you next time. Goodbye.